The idea of suing death may sound absurd at first, almost comical. But there's something profoundly unsettling about the inevitability of it all. In the case of my grandfather, death didn't just take him. It robbed him of the opportunity to prepare, to say goodbye, or even to truly understand that his time was up. It came for him suddenly, without warning and without explanation, and that is where my complaint began. At 72, my grandfather was more than just a man in his later years. He was a repository of stories, wisdom, and laughter. He had seen the world change, had weathered storms of hardship and joy alike, and yet, when his final moments came, it was as if all of that experience had no bearing on the inevitability of his end. To me, this felt like a violation of his rights. A man who had lived a full life, who had contributed to his community, should have been afforded the chance to make peace with his departure. I began to think of death, not as a natural part of life, but as an entity that makes decisions on behalf of us all. And, like any entity, it should be held accountable. There should be rules. There should be a way to contest it. Death doesn't simply appear out of nowhere. It follows a process. But why, then, does it seem so arbitrary in its arrival? It's not as if anyone can predict exactly when or how it will happen, and yet we all seem to accept that this randomness is acceptable. My grandfather was a case in point. He had lived well, had taken care of his health, and had, in many ways, defied the expectations of what life after 70 could look like. Yet, the universe chose to end his life not because of his lack of care or his age, but because it simply decided that his time had come. And with that decision, it seemed to disregard everything he had built, every relationship he had formed, and all of the love he had given. This, to me, was the injustice. I sued death because I believed that it had violated the most fundamental right of all, the right to understand and prepare for one's own end. My grandfather didn't get that opportunity. He didn't get a final say. So I took the first step toward accountability. I filed a lawsuit, not just in the name of my grandfather, but for everyone who has ever felt the sting of an untimely passing, for everyone who has ever been left in the dark, wondering why it had to happen this way. The question now was, could I win? Was there any way to hold death accountable for its arbitrary decisions? Or was this just a quixotic attempt to make sense of an inherently senseless event? In the courtroom, the challenge would be different from anything I had ever faced. It wasn't just about proving a legal point. It was about confronting something much larger, something that sits at the core of the human experience, our relationship with life and death. And so the case began, a legal battle against an entity that had never been questioned before. But I wasn't just fighting for my grandfather. I was fighting for the possibility that we might one day have some semblance of control, some small say, in the ending of our own lives. In the days following my decision to sue death, the reality of what I was undertaking began to sink in. This wasn't just some whimsical idea, some philosophical musing over coffee. I was about to enter into a legal battle with the most abstract concept there is, death itself. The sheer absurdity of the situation was not lost on me, but the more I considered it, the more I became convinced that it was precisely this absurdity that demanded action. The first step was to make the claim official. I walked into the courthouse, a place meant for more tangible matters, property disputes, criminal cases, civil lawsuits. But here I was, filing a complaint against an entity that could neither speak nor defend itself. The clerk behind the counter stared at me, unsure whether I was joking or simply had lost my mind. I handed over the paperwork, the formalities, the complaint written out in the most serious legal language I could muster. Death, as an agent of the universe, has violated the natural order by taking the life of a man who had not been granted sufficient time to prepare for his inevitable end. I could see the confusion in the eyes of the clerk. "Who is the defendant?" she asked. I paused. How does one list the defendant when the very thing you are suing is an intangible and abstract force beyond comprehension? "Death," I said, a bit too simply for my taste. The words hung in the air as if challenging the very nature of what a lawsuit could be. And so I was told to wait. In a world where justice was typically dispensed with clear parties and clear crimes, this case was an anomaly. I was sure that no one in the history of law had ever stood in that same courthouse, filing a lawsuit against death itself. Perhaps that's why the idea, the absurdity of it, took hold of me even more powerfully. In a world so obsessed with order, with control, with the idea that everything should be categorized and rationalized, here I was attempting to bring accountability to the most uncontrollable aspect of existence. The next challenge was to find a lawyer who would take my case. I made calls, sent emails, and reached out to friends in legal circles. Every time I explained my case, there was a long silence on the other end of the line. "You're suing death?" they would ask, almost with a laugh. But I wasn't laughing. I was dead serious. No one seemed eager to take on the task, not because they didn't believe in my cause, but because the concept was simply too far outside the realm of normal legal proceedings. Finally, I found a lawyer, a seasoned attorney who had seen it all. He was skeptical at first, but after hearing me speak about the issue, he began to understand that there was, in fact, a legal argument to be made here. He agreed to represent me, albeit with some reservations. He said, "This could be the strangest case in legal history, but we'll see what happens." And so we began preparing. As absurd as it sounded, I started drafting arguments, not just legal arguments, but philosophical ones. What exactly was it that I was accusing death of? It wasn't about the inevitability of death itself, but about its untimely nature, its lack of communication. I began to research, to talk to scholars, to understand death not as an inevitability, but as a force with its own set of rules and perhaps its own accountability. In this process, I realized something profound. Death was not just the end of life. It was a part of life itself, yet it was also a force that affected every moment of existence. The lawsuit wasn't simply about holding it accountable for my grandfather's death. It was about challenging the very framework we all live within, one that assumes we have no say in how or when we go. And maybe, just maybe, it was time to question that framework. The court date was set. We were about to face the intangible, the inevitable, and the absurd. As I stood before the courtroom preparing to lay out my case, I realized that the accusations I was about to present were not merely philosophical musings, but deeply rooted questions about the very nature of life, death, and the rights of individuals. The central issue wasn't just that my grandfather had died, it was how death had chosen to come for him. It was the arbitrary nature of his passing, the suddenness that left no room for closure, no time for reflection, no opportunity to say goodbye. At the heart of my argument was this: death had violated the natural order by depriving my grandfather of the time he deserved to prepare for his passing. It wasn't that I believed death itself was inherently wrong. After all, death is a part of life, something we all must face. But it was the manner in which it arrived, the coldness with which it swept him away, without any warning or explanation, that seemed unjust. How often do we hear that the end of life is a natural process, something that should be accepted as inevitable? But should we accept it blindly? Should we surrender ourselves to the randomness of fate? My grandfather had lived a life full of meaning, of love, of connection, and yet he had no warning, no chance to make peace with the world around him. He had worked hard all his life, providing for his family, helping his community, and living with a sense of purpose. And yet, at the age of 72, death decided to take him without a moment's notice. It felt as if everything he had built, his legacy, his relationships, his stories, were stripped away in an instant, as though they meant nothing in the face of death's arbitrary timing. My accusation then was not about the inevitability of death itself, but the unpredictability, the randomness, the coldness with which it had taken him. I argued that death had violated my grandfather's fundamental right to live his life fully, to know when his time had come, to make preparations, to say his goodbyes. No one should be robbed of that opportunity. We all deserve the dignity of knowing when the end is near, so we can prepare ourselves, make amends, and find peace. But how could I prove this in court? How could I make the case that death, as an abstract force, had committed a crime? It was impossible to point to any tangible evidence. There was no autopsy report to show negligence, no physical evidence of foul play. The only evidence I had was my own experience, my own grief, and the countless stories of others who had faced a similar, untimely loss. But could that be enough to convince a court of law that death, in all its finality, was somehow at fault? I also needed to argue that death was not simply a biological event, but a force with its own set of rules, its own mechanisms. If it was a force, then it must follow a system, a pattern. And if it followed a pattern, then surely there must be ways to predict, or at the very least, understand it. If we could understand it, perhaps we could gain some control over it, or at the very least, find some way to ensure that it didn't arrive without warning. If death was to be a part of life, then it had to operate within a framework that allowed for understanding and preparation. I was ready. The accusations were clear. Death had violated the natural order by denying my grandfather the time and understanding to prepare for his passing. And now it was time to present this case before the court. The trial would begin, and I would lay out the arguments that, perhaps, could change the way we view the end of life forever. The courtroom was filled with a strange energy that morning, a mix of disbelief, curiosity, and a hint of something deeper, something almost existential. I had never imagined that I would be standing in a place like this, facing not another person, not even a tangible force, but an abstract concept. The judge, a seasoned professional who had seen his fair share of odd cases, sat with a bemused expression. He, too, had to be questioning the reality of the situation. Could death really be sued? Was there even a legal precedent for something so absurd? But despite the absurdity, there was an undeniable seriousness in the air. The court had set the stage for a landmark case, one that could shake the foundations of how we understand life and death itself. And it was not just my grandfather's passing at stake here. It was the very idea that death, for all its finality, might somehow be accountable for its actions. The moment I stood to present my case, I was struck by how inadequate words seemed to be. How do you argue against something that is as inevitable as the passing of time? How do you accuse something that cannot stand trial, that cannot respond, that operates beyond the realm of human understanding? But I had to begin. The charge was clear. Death had wrongfully taken my grandfather before he had a chance to make peace with his life. I outlined the fundamental rights we all possess, the right to live fully, to know our end is near, and to prepare ourselves for that moment. My grandfather had been robbed of these rights. He had not been given the chance to say goodbye, to resolve his unfinished business, or to reflect on his life. The case wasn't about the natural inevitability of death, but about the injustice of its timing, the suddenness with which it arrived. The prosecutor, who was assigned to represent the opposing view, stood up. He was a tall, stern figure, his voice steady and confident. He didn't need to say much. "Your Honor," he began, "death is an inescapable part of life. It is not bound by human rules, nor can it be held accountable for the passage of time. To accuse death of wrongdoing is to misunderstand its very nature. We are all subject to its laws, and in that sense, no one is above it." The words stung. The argument was logical. Death was beyond reproach, beyond control. But there was something in the simplicity of the prosecutor's words that felt unsatisfactory. To accept that death could not be questioned was to accept that there was no room for justice in the face of life's greatest certainty. Was this truly how we should see the end of life, simply as an uncontrollable force that no one could challenge? The judge listened intently, and for a moment it seemed as though he might dismiss the case as too absurd to continue. But then, unexpectedly, he spoke. "This is a case unlike any I have ever encountered," he said, his voice heavy with both curiosity and gravity. But perhaps that is exactly why it deserves to be heard. We must, as a society, question everything, even the things we believe are beyond question. The room fell silent. I could see the shift in the atmosphere. This wasn't just a case about my grandfather anymore. It was a case about how we understand our mortality, about whether we have the right to challenge the forces that shape our lives, even when those forces seem invincible. As the arguments continued, I couldn't help but think about what was truly at stake here. It wasn't just about suing death. It was about confronting the idea that we, as individuals, have no agency over how or when we die. It was about challenging the narrative that death, with all its power, must remain unquestioned. If I could make my case, if I could somehow prove that death had acted unjustly, then perhaps we could begin to rethink our relationship with it. Perhaps we could, for the first time, give ourselves the dignity of knowing when the end is near, and in that knowledge, take back some of the control that death had so long taken from us. The trial had only just begun, but already it was clear that the implications of this case were far greater than I had ever anticipated. As the trial progressed, it became clear that this case was no longer just about a legal dispute. What had begun as an attempt to hold death accountable had morphed into a profound exploration of the human condition, our relationship with mortality, and our desperate desire for meaning in a world where death often seems like an unstoppable force. The courtroom, filled with an audience eager to witness the absurdity of it all, now held the weight of something much more existential. I had presented my argument that death had deprived my grandfather of the chance to live out his final moments with dignity and preparation. But now I needed to confront the deeper issue at hand. What does it mean to truly live? And, by extension, what does it mean to die? These questions echoed throughout the trial, reverberating in the minds of the jury, in the words of the prosecutor, and in the silent contemplation of the judge. Everyone in that room was forced to confront their own mortality, the one thing that no amount of wealth, power, or intellect could escape. The prosecutor, in his rebuttal, argued that death was simply the culmination of life. It was not an entity to be held accountable, for it had no will, no malice, no intention. Death, he said, is not a decision made by a conscious being. It is the result of the natural processes that govern existence. If we are to hold death accountable, we would have to question the very foundation of life itself. His words were sharp, logical, and cold. He reduced death to a biological function, stripping it of any moral or philosophical weight. But in doing so, he missed the point entirely. Death, for all its inevitability, was not just a biological process. It was a deeply personal event, one that touched every single person in the most intimate way imaginable. To reduce it to a mere function of biology was to ignore the emotional and psychological impact it had on those left behind. I countered with a different perspective, one that questioned the very notion of accepting death without challenge. We are told to accept death as a natural part of life, I argued, but is it truly natural to have no say in how or when we die? Is it truly natural to be robbed of the opportunity to say goodbye, to tie up loose ends, to make peace with our existence? I looked directly at the jury, hoping they could see the depth of what I was arguing. It wasn't just about my grandfather. It was about every person who had ever been forced to accept the arbitrary nature of death. It was about the injustice of not being given the chance to prepare, to reflect, to die with dignity. The prosecutor dismissed this, claiming that such concerns were emotional and not suitable for the courtroom. "We do not prosecute the universe for the laws of nature," he said, "nor can we challenge the inevitability of death." But I couldn't let go of the fundamental question: why do we accept this inevitability? Why do we accept that death can take us without warning, without a final moment of understanding or preparation? As I stood there, I realized something crucial. This case wasn't just about the end of one life. It was about how we, as humans, live in the shadow of death. It was about our need to find meaning in a world where we are all bound to eventually face the very thing we cannot control. And in that realization, I found the core of my argument. We are not merely passive participants in life. We deserve the right to face our end with awareness, with preparation, and with dignity. The courtroom became a battleground for ideas, where the absurdity of suing death collided with the profound truths of what it means to be human. And as the trial continued, I began to understand that perhaps the greatest injustice wasn't just the untimely passing of my grandfather. It was the way we had all been conditioned to accept death without ever questioning its right to arrive when it does. As the trial continued, the courtroom atmosphere shifted from disbelief to curiosity, and eventually to something more profound. The judge, though a man of logic and reason, seemed increasingly captivated by the philosophical arguments being presented. The prosecutor's reliance on the cold, unfeeling logic of biology was beginning to feel hollow. It was one thing to dismiss the emotional weight of death, but it was another to ignore its profound effects on human existence. In the days leading up to the next session, I spent countless hours revisiting the arguments I had already made. I realized that my focus had been too narrowly placed on the specifics of my grandfather's death. While his story was deeply personal to me, I had to consider that this case wasn't just about one man's passing. It was about a universal truth. We are all inevitably faced with the unknown arrival of death, and it is this uncertainty, this randomness, that we must contend with. The randomness of death was the central issue. It was not just an inconvenience or an inevitability to be accepted, but a profound injustice that affected us all. I took my seat in the courtroom, my mind racing with the thoughts I needed to express. The prosecutor had been relentless, emphasizing that death was merely a result of natural law, a law that no human could alter, a law that had existed since the beginning of time. But now it was my turn to point out the flaw in this line of thinking. Death may be natural, I began, but that does not mean it is just. We are born into a world where we have the freedom to make choices, to shape our lives. We can decide who we love, where we work, how we live. But when it comes to death, we are given no such freedom. We are at the mercy of an unyielding force that arrives without warning, and we are expected to accept it with grace, with no preparation, no understanding, no agency. There was a pause in the room. The prosecutor looked at me, his face betraying a flicker of doubt. I could sense that my words were beginning to break through the rigidity of his arguments. Death, after all, wasn't just a law of nature. It was something that profoundly impacted the very core of who we are as individuals. We are not merely passive observers of our own lives. We are active participants, striving for meaning, striving for understanding, striving for control over the things that shape our existence. Why, then, should we accept that death, the most defining aspect of life, should be the one thing we cannot understand, cannot anticipate, cannot influence? I continued, my voice steady but passionate. If death is to be accepted as a natural law, then why do we fight so hard to delay it? Why do we spend billions on medicine, on healthcare, on scientific research, all in an effort to prolong life? If death is simply a law of nature, why do we resist it so vigorously? Why do we seek to control it, to understand it, to delay it? The prosecutor, his confidence waning, attempted to respond, but there was a sense of hesitation in his words. "We fight against death," he said slowly, "because it is something we fear, but that fear does not make it unjust. But the fear of death," I countered, "is not an argument for its inevitability. It is an argument for its injustice. Death, by its very nature, strips us of agency. It robs us of the ability to say goodbye, to prepare ourselves. And that, I argued, is what makes it unjust." As I spoke, I could feel the room shift. The judge, who had remained stoic throughout the trial, now appeared to be deeply contemplative. He was no longer just hearing arguments, he was grappling with them. The jury, too, seemed to be absorbing the weight of the case in a way that went beyond the legal technicalities. And then the turning point came. The judge addressed the court, his voice quieter, but more reflective than it had been at any point in the trial. What you are asking, he said, is whether the inevitability of death can be reconciled with the dignity of life. You are not simply asking for justice for one man's death. You are asking for justice for all who are forced to face it. In that moment, I realized that this trial was not just about suing death. It was about redefining what justice meant in the face of mortality. It was about challenging the boundaries of human agency, about asking whether we, as humans, had the right to expect more from life than the inevitable end it promises. It was no longer just my grandfather's case. It was a case for all of us who had ever been forced to face the chaos of an unpredictable, uncontrollable fate. The courtroom had transformed from a place of legal proceedings into something much more profound. The battle of arguments, of logic versus emotion, had taken on an almost existential quality. It was as though the trial had become a microcosm for humanity's eternal struggle with mortality, a struggle that had been fought since the dawn of civilization. And now, as I stood in front of the judge, the jury, and the world, I realized that this was no longer about winning a case. It was about confronting the very nature of existence itself. The prosecutor, despite his earlier confidence, seemed to be losing ground. He had relied heavily on the notion that death was beyond human comprehension, that it was something governed by the immutable laws of nature. But my argument, now honed and sharpened through countless hours of reflection, was cutting through the veneer of that logic. "Your Honor," I began, "the very foundation of this case rests on a central truth, the truth that death is not just an event, but a process, an experience, and yet, despite its inevitability, we are given no say in its arrival. We do not know when it will come. We cannot prepare for it. We cannot choose the moment, and most tragically, we cannot even understand why it takes us when it does. And that is why it is unjust." The room fell silent. The prosecutor shifted uncomfortably in his seat, as if struggling to find a response that would match the gravity of my words. I could feel the weight of the moment pressing down on everyone in the room. We were no longer just discussing laws and legal precedents. We were discussing something far more significant, the very meaning of life and death. "Death is not an abstract concept," I continued. "It is a personal emotional experience. It is something we all must face, something that strips us of our dignity if we are not allowed to prepare. We give so much to our lives, our time, our energy, our love. And when the end comes, we are forced to face it with no preparation, no understanding, and no control. Is that just? Is that fair?" The prosecutor, though still determined, was now visibly rattled. "Your Honor, the fear of death is a universal experience. It is not an injustice. It is a part of the human condition. And yes, we may fight against it, but it is not for the courts to challenge what is beyond our understanding." But his argument seemed less convincing now. The jury was listening intently, their eyes fixed on me, their expressions a mixture of contemplation and empathy. The judge, too, appeared to be processing the depth of what had been said. His previous neutrality had shifted into something more thoughtful, more reflective. He understood, perhaps more than anyone, the importance of what was being debated. I took a deep breath and forged ahead. "The issue is not simply that we fear death. The issue is that we fear it unprepared. We fear the randomness with which it arrives. We fear the unfairness of not knowing when we will face it, or whether we will have the time we need to reconcile with our lives. This trial is not about defying death, but about acknowledging that we, as humans, deserve more than the arbitrary nature of its timing." There was a long pause. The courtroom hung in the balance, and I could see the prosecutor's words faltering as the power of my argument sank in. The truth, it seemed, was becoming undeniable. We had the right to confront death with dignity, to demand some measure of control over the way we faced the end of our lives. As the silence stretched on, the judge finally spoke, his voice calm but filled with the weight of everything we had discussed. "The questions you are raising," he said, "are questions that humanity has grappled with for millennia. They are questions of meaning, of dignity, of justice." This court may not have the power to change the inevitability of death, but it may have the power to change how we approach it, to bring a sense of understanding, of closure, to the end of life. In that moment, I knew that this case had already become something far greater than I had ever anticipated. It was not just a legal battle, it was a philosophical one, and regardless of the outcome, the trial had succeeded in forcing us all to confront the deepest questions of existence, questions that, perhaps, would never be fully answered, but were worth exploring nonetheless. The final moments of the trial were tense, and a heavy silence hung over the courtroom. The judge had listened to every argument, weighed every philosophical notion, and considered the complex questions raised by both sides. Now it was time for him to deliver a verdict, and with it to potentially reshape the way we understood death, justice, and the very nature of human existence. But as I stood there, waiting for the judge's decision, I realized something. This trial had already changed me. It had opened my eyes to the profound, universal struggle that we all face when it comes to our mortality. The prosecutor, his earlier confidence now shattered, stood by quietly, his face betraying a sense of uncertainty. Death, after all, could not be argued with. It could not be fought in any conventional way. It was a force beyond our comprehension, beyond our control. But in that uncertainty, I saw the true significance of the case. It was never about winning or losing. It was about confronting the nature of what it meant to live and die. As the judge called for silence, the entire courtroom seemed to hold its breath. He began, his voice calm, but filled with the weight of his words. After careful consideration of the arguments presented, and after reflecting on the larger questions of life and death that have emerged during this trial, I must admit that the case before us is unlike any other I have encountered in my career. The question of whether death can be held accountable is one that reaches far beyond legal precedents or the confines of courtroom logic. It is a question that lies at the very heart of what it means to be human. He paused, looking over the courtroom. The air was thick with anticipation. This court cannot and should not hold death accountable in the way that one would hold a person or an institution responsible for an action. Death is not an entity with agency and thus cannot be prosecuted. However, he continued, his voice growing stronger, this case has brought to light something that cannot be ignored, the profound emotional and psychological impact that death has on the lives of those it touches. It has raised questions about the way we live our lives and how we prepare for the inevitable end. And in that, there is justice to be found. The room was silent as the judge's words hung in the air. He was not offering a verdict in the traditional sense, not declaring whether the lawsuit would be won or lost. Instead, he was offering something far more important, a recognition of the human need to confront mortality, to seek understanding, and to demand dignity in the face of death. In this courtroom, we have not found a legal answer to the question of death's accountability, the judge said. But we have, perhaps, found a more significant truth, that in our struggle with mortality, we must never stop asking the difficult questions. We must never accept that death is something we cannot question, challenge, or seek to understand. The right to confront death with dignity, to seek closure, and to live fully until the end is a right that belongs to all people. The judge's words resonated deeply, and in that moment I understood that the true victory of this case was not in the legal outcome, but in the ideas it had brought to the surface. The case had sparked a conversation that could not be contained within the walls of this courtroom. It was a conversation that would echo far beyond the trial, into the hearts and minds of all who had witnessed it. In the end, the verdict was clear. Death itself could not be held accountable by the court of law. But the greater question of how we live, how we face the end, and how we prepare for it remained open. It was a question for all of humanity to continue wrestling with, a question that we would never fully answer, but must always ask. As I left the courtroom that day, I knew that this trial had not only changed the way I thought about my grandfather's passing, but it had changed the way I thought about life itself. We are all, in some sense, engaged in a trial with our mortality. And while we may never win the case, the act of questioning, of seeking justice for how we live and die, is what truly makes us human.